Great. Good morning again, everybody. My name is Patrick Fife. I'm LiveVoice General Counsel. Welcome to the August. I can't believe we're in August already. August legal update. Thanks for joining us on such a nice day outside. Before I get into substance, I'm just going to cover what I always cover for the first minute or two before every legal update class, and that is you need to find a way other than this class to stay updated on the law. There are just always so many changes happening in our industry. And I can tell you there's going to be more before the year ends. There's new laws that are or bills out there that are potentially awaiting the governor's signature here in New York. There's always changes happening at the federal level. So you need to find a way to keep updated on things. I'm happy you take this class, but if you can't make it every month, you need another way. And I think the best way to stay updated on things is get our weekly emails. All the content that I cover here, cover every month, you can really find it all on our website. And also within the emails we send out every week with the weekly legal tip. There's a lot of other great resources that happen to be on our website, which is lirealtor.com. All of the legal tips that go out on every Thursday email are there on the website for you to see. Everything about all of our events is on the website. I try to promote upcoming events. The big upcoming event we have in the next couple of weeks on September 10th is our annual general membership meeting. It's on Zoom, so all of you can attend. It's free. And it's not only a great way to learn a little bit more about what's happening in your association, but we've got a great free CE program that's being offered on AI and automation for real estate. So it's not just on, the general topic of AI and how you can use it to help with kind of the basic tasks. It's more about different tools that can be used for automation. I will say you've got to be careful with that. If you're going to use automation and autonomous AI, meaning not, where it's going to automatically do tasks without you telling it to, you still need a method to review the output before it goes live. But that'll be reviewed in the session. I think it's going to be a great session. Encourage you to attend. Also, on September 10th, you can vote for your LIBOR board of directors. So put that on your calendar. The QR code on the side there will take you right to the registration page. So please go ahead and register and join the many LIBOR members who already have registered. Again, the website, lirealtor.com, everything's there. It's constantly updated, so definitely ask that you take a look at it, flag it, and try to visit it weekly. The other benefit that I want you to all be aware of, and I know many of you call the Legal Support Center, but for those of you that don't, LIBOR has its own legal support center, legal telephone helpline. It's staffed by an attorney Monday through Friday, 9 to 5. And that attorney will answer general real estate related questions that you have. It's a tremendous resource, not only for you, but also for me, because I get to learn what all of you are asking about. What's troubling you? What are the common themes, threads that we need to provide more education on? So what I've been doing in the legal update is going over some of those questions, the ones that come up, more often. I don't go into specifics who asked it, but I definitely will let you know what's kind of what's troubling folks out there in the field. This question we've been getting every month for the last couple of years, and that's, are cold calls finally allowed? The answer continues to be no, and that is because we continue to be under a state of emergency in New York State. It's hard for me to believe that we are, but we are. That state of emergency has nothing to do with real estate. It has to do, at this point, the one that's still pending is overcrowding or public order at correctional facilities. This was declared in February of 2025. It's still in effect until at least September 13th. Very likely, oops, I'm sorry about that. Very likely that it will be extended. The governor has extended these states of emergency almost perpetually since 2020. And as a result, really anyone, not just real estate licensees, but you're not allowed to make unsolicited calls or text messages to members of the public that you don't have an established business relationship with, meaning that that you have not had a purchase or transaction with them in the last 18 months. They haven't made any inquiry to you within the last 3 months. And any other kind of marketing solicitation is allowed. Business to business calls are allowed, emails, anything like that. And why do I warn you? If you're reported to Department of State, they're going to have to investigate that. And the possible fine for a unsolicited text or phone call can be up to $20,000. So I don't think Department of State's necessarily actively looking for these kinds of things, but if they do, you could be subject to a $20,000 fine. Just not worth the cost. Another question that we get, I would say every month, to do with realtors who are taking listings for family members. In this case, last month, it was someone asking to, or they were in the process of taking a listing to rent their daughter's apartment. Daughter owned a house, daughter wanted to list an apartment. Mother said, fine, I'm going to take it, called up the legal support center. Well, what do I do? Do I need to make any kind of disclosure? The answer is yes. Why? Article 4 of the Realtor Code of Ethics says that if you have a present interest in the property that's for sale or for lease, you have to disclose that in writing to all parties to the transaction prior to a party signing an agreement. And you say, well, Patrick, well, present ownership interest, the example. So you have to disclose any interest you have in a property, but any present ownership interest includes an interest of your immediate family member. An immediate family includes, this is a pretty broad definition. It not only includes the realtor, but the realtor's spouse, their siblings, their parents, their grandparents, their children, grandchildren, and other descendants. So if you have a family member that you are taking the listing for, it's fine. Certainly get the permission of your broker. There are some brokers out there that I say, I know they don't, for whatever reason, maybe it's an E&O issue they don't want, or they have specific disclosures that need to be made. Check with your broker. But if you're taking a listing for a family member, your broker permits it, you have to make a written disclosure to any other party to that transaction. And we do get code of ethics complaints on this subject at least a couple times per year. So again, follow the rules, make sure that you are disclosing. Another topic. Now, this issue, withdrawals, releases, questions, you get a disgruntled seller, right? I'd say several times per month, we get questions to the legal support center. We get calls from disgruntled sellers to our professional standards department. They want to file an ethics complaint. They want to speak to an ombudsman. They're looking to get out of their listing. And the question becomes, well, how does that happen? What are the differences? Can I withdraw the listing? Can the seller withdraw the listing? Can I release the listing? Should I release the listing? So I guess the first question is, well, what's the difference? Well, withdrawing the listing, it just pauses the active marketing. The seller, in most cases, can ask to withdraw the listing. It's the seller's decision. If the seller says, I want to withdraw the listing, I want to take it off the market, the seller can do that. If that happens, that means, though, that you, the listing broker, you still have an agreement with that seller. They can't go and list with someone else. That exclusive right to sell contract still stays valid until the expiration date. You might not be marketing the property because they've asked you to withdraw it, but you still have an agreement with that seller. So the seller's still in a relationship with you exclusively, and they can't go to another listing broker. A release is different. That's a permanent termination of the listing contract. You sever your relationship completely. The seller can go off and go to another listing broker. the listing broker doesn't have to grant a release. Sometimes it makes sense, right? You could have a very disgruntled seller who's threatening all sorts of things, and you just want to be done with them. You can grant them the release. You don't have to, but in some cases, why bother? But you have to look at the pros and the cons. Second question we get is, well, what's the difference between a conditional and unconditional release? There is a difference. When they grant a release, like I said, you're severing that contractual relationship. But are you severing it in whole, meaning an unconditional release, saying our contract's 100% canceled, Mr. and Mrs. Seller, I'm letting you go. We have no obligations to each other. We have no rights to each other. I can't get a commission from you. You can go off. You can go to find a new agent immediately and do whatever it is you want. You can grant that. You can also grant a conditional release. That's the broker saying, and this could be a variety of things, but basically saying, look, we're going to part ways, but under specific terms. So the broker may say, if there's someone I showed the property to and you sell within the next 90, 180, whatever period you ultimately agree to, that then I'm still entitled to a commission. So there may be some kind of safety clause, something in there that still gives the broker rights to a commission under certain circumstances. I caution anybody out there who's not the broker. If you're a salesperson, you should not be granting releases until you talk to your broker, right? It is not, this is a theme throughout everything I teach. The agent does not own the listing. The agent does not control the listing. The listing is between your broker and the owner. So, if there's issues about releases, things like that, speak to your broker or your office manager, because brokerage policy may dictate certain things. I'm just telling you what options are out there. But these are always a decision that should be made by the broker or the office manager if you have one. All right. This question came up this past week. A lot of questions about advertising we get often, but somebody asked, is there? I heard there's an official list of advertising terms I shouldn't use. Great. I know I can't advertise. It says great for families. That's a potential fair housing, but where's the list? The list of illegal terms. There's not an official list of illegal or terms under the fair housing laws. LIBOR does have a fair housing word and phrase guideline. It will help you avoid potential fair housing claims. And if you scan that QR code, that's why it's up there. It'll take you right to that list. It's not all inclusive. I can't possibly come up with a list of every conceivable word that may trigger a fair housing complaint. These are sort of the goalposts for you to I'll say stay out of, not stay in, but just words that you want to avoid. So again, I can't come up with every situation that you should avoid, but it's just a good guide for you to avoid potential fair housing complaints. If you have specific questions about a word, a phrase, something like that, speak to your broker's counsel, call the legal support center. That is a type of question that we can provide some guidance on, and at least point you in the right direction. But if you have concerns, if you have questions, I would always consult with this list first. I know one key, most of these words, at least some of the I'll say the real do not words, they automatically search for in listings. But you certainly want to check this if you've got a question about whether there's something you can or cannot include. All right. Next topic I want to cover is I'm going to go back a little bit, but the NAR settlement from 2024. And the reason I'm going to go back and just talk about that today is because we had a kind of a bit of news on that last week. So that settlement was that class action litigation that was brought by home sellers in Missouri, ultimately settled in 2024 by NAR. There was a whole group of people that appealed that settlement and said it was not fair, and the settlement should be unraveled completely, and we need to start over. Well, the Eighth Circuit Court of Appeals, which is a federal court of appeals, said no, the appeal's no good. Settlements still fully in force. They tossed out all of the arguments to try to overturn the settlement. And there were a bunch of them. I'm not going to go through them in detail, but basically there were some groups saying the settlement payout was inadequate. Some people saying that the settlement inappropriately included home buyers and sellers. Some people said that the plaintiffs didn't have standing, meaning that they had no right to assert the claims. So there were dissenters all over the map, but the court said all of these arguments are no good. The settlement is fair, and the settlement remains in full force and effect. And there aren't going to be any changes to the settlement terms. So the settlement from 2024 is really with us for good. I know there was if you read some articles on the settlement, I think there were some people saying, well, because this isn't certain, there's question about whether all these things related to the settlement are going to be long-term practice changes. I think the decision that came out last week pretty much now makes it clear that everything related to the settlement is now with us and with us for the long haul. So I just want to, because of that, give you a little bit of a reminder, because I do, based on some of the questions that come into the Legal Support Center, and also some things that I've heard from some of you about what you deal with in the field. I'm not sure if everybody really knows all of the settlement practice changes that went into effect and is really complying with them. And it's important that you do, because if you don't, you're potentially subjecting yourself and your brokerage to liability. So the first one that I think we're pretty good on is that you can't offer compensation on the MLS. And I say we're pretty good on this because the MLS won't let you do it. If you try to do it and you try to sneak it into the agent remarks, public remarks, it's not going to work. Your listing is going to get flagged. It's going to get pulled down. So there is no offering compensation on the MLS. You can't make these indirect signals to compensation. Compensation is fully and has always been fully negotiable off the MLS. So if a seller or a listing broker wants to offer compensation to a cooperating broker, they can do that. They just can't do it on the MLS. And that's, I think we're pretty straight on that. The thing where I think we need the reminder, and from what I've seen, and I think maybe it's some of the agents that don't work with buyers that often or haven't had a buy side deal in a while. It's the buyer representation requirements that are required under the settlement. So prior to touring a home with a buyer, not after, not during, not at the closing table, before you tour a home with a buyer, you have to have a written agreement with that buyer that has to establish what you are going to be paid, the amount or rate of compensation that you'll be paid as a buyer's agent. And it has to be an actual amount or percentage. It can't be open-ended. It can't be, hey, I'm going to get paid whatever the seller is going to offer. It can't be a sliding scale. It can't be, between X and Y percent. It has to be something that I can look at and say, okay, I know what my fee is going to be, or what my payout is going to be to my broker at the end of the day. And the other thing is that whatever that amount, whatever that rate is, that's the cap. You can't get more than that from a seller, even if the seller is offering that amount. And these are rules under the MLS. They can be enforced by the MLS. They're also really embedded now in our code of ethics. So all of these things can lead to liability if you're not following them. These are some questions that have come up over the last, I'd say, year and a half to the Legal Support Center. Well, all right, is there requirements about timeframes for the buyer agreement? Can I have an agreement that just covers one home? Yes, you can have. It's really up to you and a buyer. What does the buyer want? You can start off if you're just with a buyer that you don't know from anywhere that just happens to contact you to see one particular home. You can have an agreement that just covers that one home. That's it, one day, one showing, period. And then you can gradually expand it if you and that buyer decide to. The important thing is you just need an agreement with that buyer for that property for that time period that covers the requirements that we just went over. Can you amend the agreement? Yes, but be careful. And I've seen this in practice. I will tell you, my own parents went to purchase a house, not here in New York, but out of state. And they had an agreement with a buyer's agent, and ultimately the seller was offering more compensation, and the buyer's agent tried to change the agreement on them without letting them know. You can't do that. They were just trying to increase the compensation that they could get beyond what they had originally agreed to with their buyers. Amendments should only have a business justification, right? If you're going to amend the agreement, there needs to be a reason why. Well, why should you be getting that additional compensation offered by the seller? And does the buyer agree to it? The buyer has to be, if you're going to have an amendment to agreement, it should be triggered by the buyer, explained to the buyer with full disclosure to the buyer so the buyer understands what they're being asked to agree to and what their rights are. I see a question. Do we need to have the buyer agreement date be active until closing? It depends on how your buyer agreement structured. I can't really give you guidance on a particular situation. If it has to do with when the offer was accepted, what's the trigger for when compensation is due in your agreement? It doesn't necessarily have to be active through closing, but what is the mechanism, or what's the trigger to getting paid under your agreement? Is it when you were the procuring cause for that particular transaction? If so, as long as you were the procuring cause through a date by which the agreement was still in effect, you should be covered. But it's always a good idea to confirm everything in writing. Be transparent, right? If there's any concern that you have or you believe you might not be entitled to compensation because the agreement may no longer, or it's coming up on expiration, have that discussion with your buyer and explain, hey, we need to amend the agreement or extend the agreement because it's coming up to a conclusion date. Full transparency in my mind is really what the settlement wanted and what you should always be practicing. This question still comes up, and I'm not quite sure why. There's some reason that there's listing brokers out there that think, well, before I could pay the buyer's agent, or the seller can pay the buyer's agent, I need to see their agreement. You don't. You're not entitled to. Just like a buyer's agent doesn't say, hey, listing agent, I want to confirm that you're really the listing agent, and I want to know what your compensation is. Show me your listing agreement. Would you ever do that? No. I see a bunch of people shaking their heads. Absolutely not. It's the same thing. This is an agreement between you and your client. There is the listing broker asks you to give a copy of your written buyer agreement. You should not provide it. You do not need to provide it. They do not need to confirm what your compensation is. That is between you and your buyer. You obviously should have that agreement. If your buyer wants you for some reason to disclose it to the seller, that's a different story. But you do not need to confirm what the buyer paid you. The seller should independently determine. I've also heard some listing brokers say, well, I don't want to overpay. I want to know what the buyer's agent's getting. That's between the buyer and the buyer's agent. What you decide to offer should be between you and your seller. And that should be a discussion you're having with your seller. You should be independently basing your decisions on how to address compensation based on what's best for the seller, not what the buyer agreed to with their broker. Just lastly, don't try any workarounds related to the settlement. I just think any of these are going to get you in trouble. Seller paid bonuses, if they exceed what you've already agreed to with your buyer, you can't accept it. trying to supplement some kind of agreement. This is not, I've heard, not a practice that I've heard really so much, but I think in the beginning when the settlement was just approved, some people said, well, I'm just going to have a touring agreement that says I'm just showing you the property and not getting paid. And if you decide to make an offer, then we'll write up an agreement about what my compensation is. That is not what the settlement calls for, and that is potential trouble. I mentioned earlier, you can't have ranges of compensation. It needs to be objectively ascertainable. So something concrete that I know exactly as a buyer what my cost is going to be on this transaction. And then, leaving it blank. We'll fill that in afterwards once we know what the seller is going to offer. That's not being transparent. That's not letting the buyer know what their cost is going to be. And that's what you need to be doing in these agreements. If you have any other questions, I mean, certainly call the Legal Support Center. I do think if you're a broker, an office manager, I would encourage you just to kind of do a refresher on all of this, especially for some of either your newer agents, your part-time agents, those that don't practice buyer agency too often. It's just a really good idea to make sure that everybody is, getting a refresher and in tune on all of these things. Next topic I want to move on to, and I'm going to cover a couple different things here, is news versus reality, about, especially with fair housing. I mentioned at the very beginning, you need a reliable source for your information. And I think that LIBOR provides that. The problem is the news. And I'm not saying that the news puts out false stories, but the news doesn't always accurately capture the truth when it comes to things like fair housing. And that's just because they're not necessarily, they're reporting a headline. They're not necessarily reporting the nuance when it comes to the law. So what do I mean by that? I actually looked this up yesterday. And before I move on to this, I see there's a question about the no workaround slide. All of these slides will be made available on the website. So if you go on to lirealtor.com and look at legal update, by tomorrow, the slides will be up on the website. So you can feel free to download them there. And this will also be recorded so you could share it with people in your office that miss it, any colleagues, that sort of thing. All right. So emotional support animals. I just, Google News searched emotional support animals, and, are emotional support animals allowed? And here's some of the headlines that came up in Google News. So you see HUD strips protections for emotional support animal and housing. Emotional assistant pit bulls are no longer protected from eviction. HUD moves to limit assistance animals for disabled tenants. So if you just read these headlines, which, look, we're all guilty of doing, right? Especially on social media, you see a headline. My kids do it. Hey, Dad, did you know? Blah blah blah. And you just read the headline, and you automatically assume the headline is true. So if I read these headlines, I'm thinking, oh, emotional support animals, you're not allowed to use them or have them in housing anymore. Well, it's not really true. So what are these headlines reporting? There was a recent memo from HUD, which is the Federal Agency Housing and Urban Development, that talked about emotional support animals. Oops, I keep skipping ahead. I'm sorry. So that was in May. They issued a guidance memo and said, we had given prior guidance on emotional support animals, and we're taking a much narrower approach. And basically saying, well, we're not going to enforce fair housing, reasonable accommodation cases for emotional support animals. We're only going to apply those types of cases to service animals, which are animals that are trained to perform a specific task. Service dogs. That's it. We're limiting our enforcement to those particular situations. Well, that's not meaning that it's a big difference. So, a couple things. One, New York State laws supersede in New York federal law. They are more, they provide more coverage. So under New York state law, and we're all practicing here in New York, landlords and real estate professionals still need to provide reasonable accommodations for individuals who require emotional support animals. Also, just because HUD, the federal government, isn't enforcing it, doesn't mean that private citizens can't bring claims. Fair housing agencies can't bring claims. Doesn't mean that there's no longer testing for any of these things. So all that announcement is just one group, one federal enforcement group saying we're not looking at the law the same way as everyone else. So when it comes to fair housing here in New York, if somebody has an emotional support animal and they require a reasonable accommodation for it, the reality is an apartment can't deny it. So things are no different here in New York. Landlords can have a no pet policy, but emotional support animals are not pets. They are a tool to help someone that has an emotional disability overcome that disability. So if somebody with an emotional support animal or claiming to have an emotional support animal has a letter from a physician, mental health professional, social worker, and says that this person requires an emotional support animal, that's it. They're entitled in New York to have that emotional support animal. Despite the fact that HUD may not be enforcing the law that way, the law in New York is and remains that emotional support animals are on that same, treated the same way as service animals. So if the individual requires it and they have a medical professional saying they require it, that landlord should be accommodating the request. And I see a question, no fee for that animal? Correct. So emotional support animals and service animals, you can't apply any additional rent, any additional deposits, additional insurance, any kind of additional requirements because they're not pets. My guidance to all of you is when you verify that somebody has an emotional support or service animal, you look at it like glasses. That animal is not a pet. It's a tool to help someone with a disability. Just like your glasses assist you with a visual disability, the emotional support animal assists someone with emotional disability. A service animal may assist someone with another disability. So you can't apply any kind of barrier, financial, physical, or otherwise, to that person. So my guidance to you is, and this is, it's not directly related, but one thing I will encourage all of you, and you have to do if you're dealing with tenants, is provide the reasonable accommodation and modification notice to all prospective tenants. The New York State requires it. There's a notice, and we'll talk about it again in a minute. It's a required form that you have to give to all prospective tenants at first substantive contact. It's a notice disclosing tenants' rights to reasonable accommodation for persons with disabilities. And it lets tenants know you have the right to request a reasonable accommodation, and you have to give it to every tenant at first substantive contact. And I encourage you to, if you haven't done it, you should take a look and read through all the disclosure forms that you're required to give people in different situations. If you just read that form, it states right here, this is to every tenant in New York State. They get this and they should be getting it. It says, if your healthcare provider provides documentation that having an animal will assist with your disability, you should be permitted to have the animal in your home despite a no pet rule. So this form is telling you what your obligation is as well. I just think it's a really good idea once a year, maybe every 6 months. Just do a refresher. Look at the forms you're giving people so you can answer questions and you're more knowledgeable about them. But this form in particular lets tenants know that if you've got an emotional disability or physical disability and you have an assistance animal, you're permitted to have that animal in your apartment. All right. So another headline that you may have seen, this one's a couple months old. This goes back to about March, but there's headlines out there that say Section 8 in New York no longer protected. Landlords can refuse Section 8 tenants. You look at this third headline. Section 8 below, New York landlords can now legally refuse vouchers after court ruling. So you read these headlines and you're like, wow, landlords can do that. Okay. Um, no, that's not the case. So what are these headlines reporting versus what the reality is? Well, they're reporting that there was a court ruling back in March that said New York's lawful source of income protections can't require property owners to participate in Section 8, and said that New York's source of income laws, at least with respect to Section 8, were unconstitutional. And the court that decided this was an appellate court, the third department. It's an appellate court up in Albany. But that court ruling doesn't change anything right now. It has not changed the law. That decision's being appealed. The New York State Attorney General filed an appeal back in March. And in New York State, when the Attorney General appeals a ruling regarding constitutionality, that ruling gets stayed. That's the law in New York. So even though you have a court saying unconstitutional, it's not yet unconstitutional. Not until the New York State Court of Appeals has heard this and made its decision will we know whether the law is unconstitutional. So right now, all lawful source of income protections in New York State are in full force and effect. That includes for Section 8. That includes for any kind of vouchers. There has been no change in the law at all. It's important, like I said in the beginning, for you to be updated on things because this could change. The Court of Appeals could issue a ruling that definitely changes things. But for now, nothing's changed. You have to apply and conform with all source of income laws. So you should have procedures in place, and you should always have had procedures in place that treat all tenants the same way, regardless of where they get their income from. So you should have a standard set of questions that you apply to all tenants, regardless of their source of income. So whether they get Social Security, their income comes from a job, or their rent is being paid by a voucher, you should be treating all prospects the same way and asking the same set of questions, such as, and this is not meant to be an exhaustive list, but the types of questions you should always be asking is, where are you looking? How many bedrooms are you looking for? And what's your price range? And then dependent upon what that person's income amount is or voucher amount is, you're going to help them on that basis. And you're always going to show all voucher holders the same apartments you would any other prospective tenant, regardless of their source of income. It's just like you would show all people of different races the same apartments, regardless of their race. You don't treat anyone differently based on where they get their income from. Last topic that I want to talk about in this particular section is, if you again look at the headlines, do a Google search and say, can realtors talk about crime in schools? You look at the headlines and you see that is something that we can just keep on mute. We've got somebody who is. Thank you. Again, that's why I need everybody to stay on mute. I really appreciate it. So you look at the headlines and you say, well, can realtors talk about crime in schools? You do a Google search and look at the second headline. Feds greenlight realtors to talk crime and schools again. You think, okay, I can talk about crime in schools. Well, what is this headline reporting? The headline's reporting there was a recent letter, again, from HUD back, this is April, to people in the real estate industry. It was called a Dear Colleague letter, that said, in HUD's view, real estate professionals can talk about crime rates and school quality without violating federal fair housing laws. the reality is that letter can be overread as permission to just discuss crime in schools at will, without regard to any state law, and to give your subjective opinion about crime, about schools. That is not what the reality is. In New York, and even in other states, but New York has obligations that far exceed what federal guidance is. And there certainly is a risk that remains if you discuss crime and schools. So New York law, regardless of what the federal government says, provides its own standards. What you should be doing is providing consumers with access to information, not your opinions about crime in schools. You can provide access to to objective information. And in fact, that's what NAR, that's what we've encouraged for years. Give people factual information, point them to third-party resources about schools, about crime. But what you do not want to do, and what you should never be doing, is don't give your subjective opinion. Don't give commentary, about, I think these schools are bad, or even I think these schools are great, because point them to the information that the schools put out. That's what you should be doing. You should be using caution about how these topics are discussed, because otherwise you could be potentially in violation of fair housing laws, and looked at as steering somebody. The risk isn't the topic, it's just how it's presented. How you selectively frame things as saying, hey, this is a safe neighborhood, a good school, a bad area. That's not your role. You want to be objective, point to sources, let the client or customer decide what they think is good, what they think is safe, what they think is bad. Don't provide your own interpretation. So where can you get information on how to effectively do that? We wrote a legal tip. This was before the HUD memo. And if you scan that QR code that's on the screen, it gives you just some best practices for handling client questions about school districts. It is something that you can look at, and there's a number of things on our website, but I think that legal tip in particular, will give you some guidance. I also think it points to some guidance that NAR has put out as well. I want to just quickly get through a couple more topics, and I do see there's a couple questions up in the chat, and I'm happy to go over them at the end, but I want to move along a little bit and just give a couple warnings. First one is just about website privacy demand letters and just taking good care of your brokerage's website. So there's been a lot of threats out there, a lot of attorneys, I call them the bad attorneys, but a lot of plaintiffs' attorneys who are kind of after operators of websites, not just real estate websites. I think if any of you have been on the internet lately, you will see, I think, almost every website I look at. I was looking to potentially lease a new car the other day, and every car website I went to, or every vehicle manufacturer, car dealership website, there's now all these like pop-ups, confirm your privacy settings, confirm your acceptance to cookies, confirm your, it's not a coincidence. A lot of businesses are being targeted by these attorneys, claiming that by not giving consumers the option or disclosing that you're using some kind of pixel, cookie, tag, whatever it is, analytics, that you're violating consumer privacy laws. So as a result, you'll see a lot of businesses now making you have to click something before you can go through the website. And that click, most of you probably aren't reading it, but it is an acknowledgement that you're consenting to those types of things, or saying, I don't want, and you opt out of it. Well, our industry is being hit with the same thing. And it matters because there are attorneys out there who are making claims. There's some that are using a law in California. Even though we're outside of California, they're saying this law applies. And they're suing businesses in California because they're saying, well, I'm a California resident, or I represent a California resident who's visited this website. So it's very important to take these things seriously, because if you don't, It's not yet clear how the courts are going to handle it. It could be a cost for you and potential liability for you. And just defending a case like this alone can be a major, major expense. So if you're a broker and you get any kind of letters like this, notify your insurance carrier, talk to an attorney, preserve anything on your website, evaluate the claims. But what should you be doing? Hopefully, you never get one of these letters. But the thing that I think all brokerages, real estate professionals should be doing, look at your website privacy policies. Put in, if you don't already, speak to whoever created your website. There are very easy things you can put, some kind of consent banner, a pop-up that discloses what your website tracks so that consumers are aware. Ideally, you want something that they have to click through, but at the very least, you want to have some disclosure on there about what kind of tracking technologies, if any, are being used. So talk to your website vendor, whoever that might be, and then just kind of do a general overview of your digital marketing practices, and encourage all of your agents to do so. Remember, if you're a broker, you're responsible for supervising all of your agents' advertising, including any advertising they're doing on the internet. Also, a good opportunity or time to look at all of the other requirements for your website. Remember, every website in New York State that a broker operates has to have a link to these 3 documents on it. The first one has to be on every real estate website. So even if you're an agent, you have to have a link on your website to the New York State Housing and Anti-Discrimination Notice. It's got to be prominently displayed. And then on the brokerage's website, you have to have that reasonable accommodation and modification notice that I mentioned earlier that has to be given to all tenants, and also your broker standard operating procedures. I will say that Department of State, if they get a claim against you, they will, or one of your agents, they will look at the brokerage's website. And if you don't have these things, they will fine you. And if you've got agents who don't have the housing and anti-discrimination notice, those fines can add up. So important just to go through your website, make sure you have links to all 3 things. If you've got questions about what these things are, please go to our website, lirealtor.com. We've got plenty of articles with links to the forms for each one of these things, or templates that you can use for your brokerage. Also, make sure that you've got your correct license name and title for everyone in your office. I've seen brokerages who have been fined because they've had 30, 40 people in their office who they've identified as real estate agents. That's not the way that you have to do it in New York. Advertising requirements say you need to use your license title. So if you're a brokerage, you have your website, you should be calling those people real estate salespersons, licensed real estate salespersons. Use the correct title. If you don't, that can be a $500 fine per licensed individual. Take a look at, and it was one of the handouts that was with the materials that you got today, the New York State Department of State Real Estate Advertising Checklist. This is what Department of State uses to review advertising for any complaint that comes before them. So, word to the wise that if you're brought in on any kind of complaint before Department of State, even if you're vindicated and it's a completely fabricated complaint, Department of State will still look at your advertising, which is why I encourage all of you just to do it on your own. Do it every 6 to 12 months. Take a look at this advertising checklist and run it against your own advertising. If you didn't get the attachment, the QR code that will take you to it is there. Department of State's also looking at AI. There's no formal policy that they have regarding AI, but there are laws that they will apply to the use of AI in advertising. They are looking for transparency. They're looking for honesty. They're looking for accuracy. If AI is used in some way that alters things or puts out information that is not accurate, Department of State's going to look at that and they're going to fine you. And it could also be a licensing issue. They did put out a warning last year in November to all of you. And I think because they did that, that to me is a signal that Department of State's taking this very seriously. Um, just be careful with the use of AI. This past weekend, I was just using it for my own home. I was doing some yard work and I said, it would look great if I maybe change something, the location of a bed. So I just took a photo of the front of my house and said, give me a suggestion or give me a depiction of what it would look like if I move this bed here. And it did it, but I didn't even notice this. I showed it to my son and he goes, well, do you realize that it also changed our garage door from two doors to one? It moved the location of a light. It eliminated another light. And I didn't ask it to do any of that, but it did. You just, that's why you have to be so careful in what you're putting out there. So if you're using it to digitally stage a room, whatever it might be, give examples of other things. Make sure it didn't make any other changes. It really, can do things you're not expecting. I see a comment about like, well, minor editing, taking out an eyesore like a garbage can. Yes, that can be done, but be careful. You may ask it to just do that. And depending on the program you're using and the type of program, it may do a lot more. And you have to really look at it and check the work. That's why I strongly encourage all brokerages to have some kind of AI use policy and also have platforms that they require if you're going to use AI. Not all AI programs are created equally. There you can certainly use certain programs that are better than others, and I think brokerages should really invest the time to see what those programs are and require those because I was just using a free version of an AI program just for my own purposes. I wasn't putting my house on the market. I was just trying to mess around and get ideas for my own house. But if you're using this to make some minor changes to a photo, really want to make sure that you're using a top of the line program that isn't going to inadvertently make changes that you might not pick up on. Because if you do that and you put those photos out there and they're not an accurate representation of the property, you can have issues with Department of State. You can have issues with Article 12 of the Code of Ethics. And again, these are things that I've seen. We have had professional standards complaints come in based on parties claiming that photos were altered and there were not proper disclosures made as to what was altered. So really important that if you are a brokerage and I'm sure every brokerage is allowing the use of AI, but you need to put some guardrails in place. And even if your brokerage doesn't have a policy, I encourage all of you to just take the time to make sure that you're using really solid, platforms, programs that don't make mistakes or that at least limit mistakes, and that you're really checking the output before you're just putting it out there to the public. Last topic. I've covered this the last 2 months, but it continues to be something that I keep hearing about. And it's just exploded both at the local level and the national level. But these fake Zoom and Teams link scams, video conferencing scams, it's become a very big problem. I know a number of you have told me, whether it's at a committee meetings, other meetings events that I've met you at, that this is something that you have people have attempted on you. I know most of you have thwarted it, but it's a problem. So what is it? It is basically fake sellers, fake buyers sending you Zooms, Teams links to try to get you to engage regarding a property. And how the scam works is they're posing as prospective buyers, often buyers, sometimes sellers, but they see your listing, right? You're listing 123 Main Street. And they will ask you really, either through email, text message, whatever it might be. Maybe it's an email, and they say, "Hey, I saw that you are listing 123 Main Street. I'm very interested in that particular neighborhood. I also saw that you listed, 789 Main Street last year. I was interested in that property, but I missed out." They kind of lure you into this story that's really based on factual information. I see that the property only has 3 bedrooms, but there's a den. I'm wondering if that den could be converted into a bedroom. I'm ready to make an offer, but I really need to get that information. I don't have time to go see the property yet. I understand it's a hot market. I want to get on this right away. And I'd also like to see you in person. Can we just jump on a quick Zoom? So you're thinking, great, I've got this buyer, and they entice you, and again, they will act very legitimate. This is not somebody who's like just with kind of broken sentences sending you something that looks suspect, looks really legitimate. They want you to move quickly, and they'll send you their own Zoom link. Well, that Zoom link is not a Zoom link. It's something that's going to install malware, take you to a fake login page that's going to ask you to put your information in, download malicious updates. It's people looking for you to move quick. Often they're going to say, "I'm out of state. That's why I need to do this. I can't meet you in person." They're going to create urgency. Don't fall for it. Always, if you're going to video conference with anyone new that you don't have an established relationship, I would even say people you have an established relationship, use your own tools. Whatever your brokerage uses, use that platform. You generate the link, you send the link. That is the safest practice. And if you are a victim, you've got to report it immediately. Tell your broker, get your IT team involved, and report it to potentially the authorities as well. Because if they've basically found a way to get into your credentials, get into your information, you may be exposed in a variety of different ways. So just be careful because, again, that is a scam that is out there, in particular here on Long Island. So with that, I know we're at the end. Appreciate everybody's attention today and hope everybody has a nice day.